Please be seated.
Welcome to the Fourth Circuit. We're glad to have everyone this morning. We have three cases, beginning with case number 25-1350. We'll be glad to hear from you, Mr. Hawkins.
Thank you, Judge Quattlebaum. May it please the court, members of the panel. I'm Richard Hawkins. I'm with the Hawkins Law Firm. I'm here this morning, and it's my privilege to be here this morning on behalf of the appellant, Mr. Kelly. Your Honors, back when he was a lowly justice of the New York Court of Appeals, pre-Supreme Court Justice Benjamin Cardozo famously said that a beneficiary about to plunge into a ruinous course of dealing may be betrayed by silence as well as by the spoken word. And silence here betrayed Mr. Kelly. Silence betrayed Mr. Kelly with fidelity when they failed to tell him in his November 2, 2020 conversations about the connectivity between the key transactions at issue. Silence betrayed Mr. Kelly from Altria when they failed, or it failed, as part of its benefits review to even address the issue of connectivity. And then silence failed Mr. Kelly one more time when Altria kept him in the dark when he specifically asked for the administrative services agreement that is covered under the ERISA statute, and they failed to provide it to him. Now, all three claims were presented to the district court, and the district court granted summary judgment against Mr. Kelly for all three claims. And we believe those rulings are erroneous. They ask that they be reversed and remanded, sent back, and with respect to the A1B claim, if necessary, to be sent back to Altria for further review. Now, before I get into the three claims, and I know the facts are set forth in all of the briefs, but I do want to set the table. Back in 2020, Mr. Kelly had a 401k in the DPS plan that was sponsored by Altria. Those were planned funds. They were kept by Altria and managed through various interactions with Fidelity. And he wanted to get them out, and he wanted to get them out as quickly as possible. And that required many separate transactions. There were a lot of moving parts. And those parts, in some levels, were explained to Mr. Kelly by Fidelity. There were two key transactions in order to get all of his money out. We call it the in-kind transaction, and that's the selling of 3 different shares of stock, Kraft, Heinz, Philip Morris International, and Mondelez. And they did that in a way that maximized tax savings. So it took a while to get that transaction completed. And then there was the cash transaction. That's transaction number 2. And that was the transaction that involved the sale of his index fund and shares of Altria stock.
So would they, were the funds, this isn't really that pertinent to the claims, but I just want to make sure I understand it. Were the funds they were in retirement funds before these two things took place, right?
Correct.
Were they being moved from retirement funds to non-retirement funds?
He was liquidating his 401k.
Okay, so that would have had tax implications, but those aren't the implications that necessarily are the ones from the net NUA tax planning, correct?
They are, but that's not part of this case.
Right, okay.
I mean, I guess it's the right way to say it. He had over $5 million in funds. The NUA was part of it. The cash was $3.9 million. And the two transactions required different settlement periods to be completed.
Right.
And Fidelity explained those two periods. They said the cash transaction is shorter, 3 to 5 days, if that. And the in-kind transactions, because they have to do all this additional paperwork and evaluate the asset basis, the stock basis, it takes longer, and they said 7 to 10 business days. But what they didn't tell him, and there's no place in the record where they did, on November 2nd, November 5th, November 10th, they finally revealed it, but no time when he could have made a difference did Fidelity tell Mr. Kelly that the transactions were linked. As the Fidelity representative told him on November 10th, after he couldn't do anything about it, told him they were connected at the hip.
As I understand it, there's a denial of benefits claim and there's a breach of fiduciary duty claim. I know there's other claims about the documents and attorney's fees.
Correct.
But let's just talk about those two, what I call primary liability claims,
Sure,
for lack of a better word. This is really how we review the first claim, the denial of benefits claim. You opened with this quote, and I appreciate that quote, but in the context of a ERISA plan like this, we're really looking, I think, at administrator's review of the claim.
You are.
And we're not, I think they are, whereas we would normally maybe say, is there a question of fact here, a question of fact there? We don't really look at that claim. We look at whether it's reasonable. And so first, from our standard review, do you agree that's how we look at the first claim?
I do.
So if there was in theory, a question of fact, if this was a fraud claim,
Right.
we wouldn't look at it that way. It's just whether it's reasonable.
For count one.
For count one.
And I think it's been said that standards review are like offensive linemen.
Yeah, someone said that.
Someone said that.
Yeah.
But every now and then, that offensive lineman gets beat and the quarterback gets sacked. And here, Mr. Kelly got sacked because the committee didn't do its reasonable review. And you're right, you're not asking whether it's right or wrong. What you're asking is, was the denial reasonable? And the question becomes, how do the Booth factors come into play? And the court, of course, has addressed 8 factors.
What's your best argument that they did not do a reasonable review?
My best argument is factor 5, which is reasoned and decision-making process, and a focus on 2 words, connectivity and PowerPoint. And I've already...
What was the second one?
PowerPoint slides, and I addressed the connectivity kind of early on here, but the PowerPoint presentation was a presentation, it's at JA 719 through 737, I'm sure you've all seen it. It was the product of essentially Altria's experts review. Tom Hodelang, who was a director of benefits, and their outside ERISA counsel put together this package that was intended to synthesize all of the information from the claim file. The transcripts, the denial letters, the claim letter. They did their own research about values, and what that PowerPoint shows, and this is why it's an unreasonable denial, that PowerPoint shows that Altria, through its members who presented to the benefits committee, knew that Mr. Kelly's claim was not only that it was a delayed payment, but that it was a lack of information on that first day and that he would kept his money out of the market. They knew that Fideli didn't tell him until at least November the 10th, according to their own documents. They knew he suffered losses, and they knew that they had a path by virtue of how they were reviewing in their scope of review to either grant the whole thing, deny the whole thing, or grant it, as they should have, and award at least something, because their own internal document showed that he had a ceiling, Mr. Kelly had a ceiling of $207,000 and a floor of $32,000. And just for ease of reference, it's PowerPoint slides 3, 13, 17, 18, and 19. And I submit to the court that those are dispositive. I mean, we can go through the entire transcripts. You can go through the conflict of interest, which I do think is important, although I submit that's the icing on the cake. Mr. Whitaker was somebody who had a previous relationship or previous interactions with Mr. Kelly. They weren't positive. We can spin them all day long, but I think the proof is in the pudding, in Mr. Whitaker's own reticence at the very end to say, I don't want to sign the letter because of my previous interactions, and I don't think there's any way to portray that as a positive.
Well, let me ask you this, but you would agree before the appeal before the board, he did not raise that conflict at that time.
We didn't. And I think the answer is we thought we would get a fair review, and it was after the fact, when we got the discovery, when we got that email. I mean, there was some concern about Mr. Whitaker ahead of time, but when we received that email, and I reference for the court, I believe it's JA 976. Once we got that, it kind of confirmed something that we were concerned about, and that is they didn't do a proper review. And again, the proof is in the denial letter. The denial letter
you may
never
or may
talked
not
about.
I'm sorry, you
No,
may
no.
have not had a good reason not to bring it, but what's the effect? I mean, if you didn't raise it then, do you get to raise it now?
Sure, because the 8 Booth factors apply regardless of what you argued at the claim level. I mean, if you argue, I mean,
But how could it be unreal? So is that right? I mean, when your claim is whether someone reasonably reviewed the record, and just on the conflict of interest, if you don't challenge that, you're saying it was unreasonable for them to have someone involved that you didn't complain about?
No, I'm not saying that. What I'm saying is that conflict of interest in normal ERISA cases, you see this in welfare benefit cases all the time, you know, you don't challenge the conflict ex ante because you don't necessarily know that it will be a conflict, but you do know that there's an institutional conflict. We raise that here. We raise that in our complaint. And Helton versus AT&T from this court in 2013 is a case we cited, recognized that an internal benefits committee made up of high-level corporate employees looking over at a benefits claim to be paid out by the fund, it raises a concern. You don't have to raise that. That's an obvious conflict that exists on its face. It's the fox guarding the hen house. But Mr. Whitaker, typically when you deal with a conflict of interest, you deal with it as a matter of discovery. And this court and the Supreme Court in Glenn has held that that can be kind of its own separate inquiry. And so you don't always have to raise it ahead of time. And I think what we thought is that we were going to get a fair review. And I think when we realized that the MCEB had only reviewed half of Mr. Kelly's claim, they had never addressed the connectivity, even though the PowerPoint slides put it right in front of their face, that we didn't get a fair review. And then when we get the email from Mr. Whitaker, it raises even more red flags. So, Your Honor, we don't need a smoking gun, and Your Honors can conclude that it was not even relevant to Your Honor's decision. It doesn't change anything. It's as I said, it's the icing on the cake, but it's not the raison d'etre that we win.
I think on your on that claim, on the conflict of interest, or the district court says that there's nothing in the record of actual bias.
You don't need it. I mean, the actual bias is very rarely something that somebody's going to see. They're never going to say, "Oh, I hate this person, and therefore there is the bias." But the bias is obvious from looking backwards at what happened. You see the statement by Mr. Whitaker, and you look at the fact that the committee met for hours. They apparently listened to these calls. They had this PowerPoint presentation where the linkage is right there front and center, and they ignore it. Now, I can't say who did what in terms of emphasizing what should be ignored and what should not, but we raised that flag after when we see it, and we can recognize that it wasn't a full and fair review. I mean,
Can I ask you, can we move to the breach of fiduciary duty
Absolutely.
issue? So to prevail on the breach of fiduciary duty, obviously you need to have a fiduciary, and my understanding is your claim is that Fidelity was functioning as a fiduciary, but I don't see that in the
Okay.
agreement, and I'm hoping that you can help us by identifying what discretionary authority Fidelity possessed in your view that would make it a fiduciary.
They had the discretion to help set up the transaction. What they did is they advised Mr. Kelly about what strategy to take to get his money out.
Did they advise, or did they just tell him what his options were?
I think it's both. And the way I say that is because if you listen to the conversations and you hear the flow, there's a disclaimer here, there's a disclaimer there, I understand that. But if you listen to what's being asked, Mr. Kelly wasn't seeking investment advice. He didn't ask what item to put it into necessarily. He didn't say, I want to, is which stock is better. But he asked, how do I set up the transaction to get my money out faster?
And
Fidelity,
is that discretionary? I mean, I did read the transcripts, and I
I'm sure you did, Your
read
Honor.
them as giving your client options, and that doesn't strike me as discretionary.
I appreciate that, Your Honor. I respectfully disagree. I believe that what he was asking, he had his experts on the line, but Fidelity were the experts of the machinery of the plan. And so they were giving him options, but they were steering those options. And I believe that's how, at least as a matter of interpreting the facts in favor to Mr. Kelly, which is what you do at summary judgment on a breach of fiduciary duty claim, that at the very least there's an issue of fact as to whether or not they were acting as a fiduciary. And I know, we focus on the first two calls to see what they said and what they did, but I think it's reasonable to understand that Mr. Kelly believed that he was getting advice. And if you look on pages JA 508, 509, and 510 of the transcript, you'll see he said, I wouldn't have taken this path without you.
There's advice and there's facts.
I understand.
He called and asked for information.
Correct.
And called the customer service number or whatever and got information for sure. But, you know, and you know, it just seems, that definition of fiduciary would be extremely broad. I mean, if you call, you know, it's clear he has decided to move the funds. He wants information about how to do it as quick as possible, and certainly he asks that and gets information. But it just seems if anyone is, you know, with their mind made up about what they're going to do, and you call someone and ask them, you know, for information, that would make breach of fiduciary claims extraordinarily strong or broad.
I agree, and we are not asking this court to issue a rule of law that says that, you know, every time somebody calls a call center or a customer service center that's supporting a plan, that all of a sudden they become fiduciaries. We're asking this court to look at the specific facts of this case.
Yeah, but, I mean, that's fine. You're not asking us to do it, but if we rule in your favor, then everyone else is going to say, look, this is a call center, and if they're a fiduciary, then who isn't?
Well, I think, Your Honors, as the authors of any opinion have the power to confine it, but I think what we would say here is that Fidelity went farther than simply acting as a record keeper.
But I was
or
going to
simply
ask you this, how is this any different than our Health South case or the Adams case, where it discusses ministerial administration? I mean, because that's what it seems like.
It seems like it, but if you listen to the dialogue, he is asking and he is responding, he is choosing from what they are giving him based on the emphasis that they are giving. And I think if you listen to the Raleigh call, the second call on November 2nd, the tone of that discussion, there's a push to Fidelity assets, there's a push to Fidelity products and accounts, and I think that's the key. And I appreciate your court's comments. I have 30 seconds, so I'd just very briefly like to address the administrative services agreement. I think the textual piece here, the issue is whether or not the plan is, or the ASA is something under which the plan is managed. I think that's the key
If we
word.
agree with you, what's the proper course? If we agree with you on the administrative services agreement, that it was indeed covered by the statute, what's the proper next step?
The proper next step is to send it back down to the district court for a question of penalties, because I believe that's a discretionary question for the court.
Isn't there a need also to determine materiality?
Explain, Your Honor, please.
It's my understanding that if the penalties are not necessarily warranted unless the document would have been material to your claim.
Oh, I think that's right. I think that's right. I think here there can't be
So
any...
it's not just a determination of penalties. There needs to be a second look at the document itself to see whether it would have made a material difference to your claim.
Oh, I'm not sure it goes quite that far, because I don't believe that a claimant has to be prejudiced. That the showing of prejudice is not required for purpose of a penalty. But I think here there would be no doubt that it was material, because Fidelity relied on it, and so did Altria at the various earliest stages to say they weren't a fiduciary. So I don't think there's any question it's material. If we had it ahead of time, we may not have even sued for a breach of fiduciary duty. But the fact of the matter is, we think that the next step would be to send it back down.
Well, let me add, I know you're over time.
It's all right.
If it's
Go,
okay.
no, yeah, absolutely.
I don't understand how you get past the language in 1024B4 that says that that this fiduciary authority has to be delegated, and then if you look at the ACA, I mean, it expressly says the opposite, is not any discretionary authority, that this is just, that there's no fiduciary duty here between them.
And I want to understand your question, Your Honor. Are we focused about the disclosure claim or the fiduciary duty claim?
No, the disclosure claim.
Okay. Well, I think it's important to look at the actual text. There's nothing in the text that says that a delegation of fiduciary or discretionary authority has to be part and parcel to whether or not a document be disclosed. There's no limit on that in the statute itself. I think the statute's very clear. It says you have to provide it if it is a document under which the plan is managed, and Fidelity, the plan doesn't function without Fidelity, whether they're a fiduciary or not. They're more than a record keeper. They're providing administrative services, and that's in the Schedule B in the document. Whether they're a fiduciary or not is irrelevant. The statute doesn't require that.
Okay, but back, and then I guess in follow-up to Judge Berner.
Yes.
How do you, I mean, if I'm looking at the plan and it clearly says that they are not a fiduciary on your first issue.
Okay, the plan says that they're a record keeper. The ASA specifically says who is and is not a fiduciary according to their own terms. But to Judge Berner's question and to yours, the question then becomes, all right, let's say it's covered. All right, so it should have been produced. And then the question is, should penalties be awarded? And I believe that's a multi-factor inquiry related to the materiality and then whether or not they should have known or whether or not they acted in bad faith or had intentional misconduct. So I appreciate the court's questions. Thank you very much.
Thank you, counsel. You have a few minutes on rebuttal when you come back. Counsel?
Good morning, and if it please the court. My name is Mike Schabelsky. I'm counsel for the two Altria defendants. I would like to spend the majority of my time, I think, addressing the Altria fidelity contract claim. But first, I'd like to make just a couple of observations about the denial of benefits claim that was discussed this morning.
Just so I understand and know who to direct questions to, if our questions relate to the breach of fiduciary duty claim, is that more related to your colleague?
Mr. Field,
Okay.
who is Fidelity's counsel, will address those matters, Your Honor. But if you have a question about the contract and how that might bear to it, I'm glad to answer those as well, obviously.
And the document disclosure questions?
That I will cover that, Your Honor.
Thank you.
All right. On the denial of benefits claim, just a few quick points. First, Your Honor, you're absolutely right. The standard of review for this panel is not to decide this anew, but to decide whether or not Altria abused its discretion in denying the claim.
Would it be abuse of discretion? The argument is that when you don't even address connectivity, you by definition abuse your discretion. What's your argument in response to that?
Yes. The review panel relied on two principal reasons for denying the claim. The first was whatever confusion may or may not have existed from the November 2nd call, it was clarified by the November 5 call before the rollover was actually initiated. And in that call, the Fidelity representatives clearly said the components of the rollover could take several business days. And in fact, what happened is that both components were completed even sooner than had been estimated in that November 5 call, 3 business days. So both of them, components, were completed by I think it was November 12th. So in fact, the rollover to both components had been completed in tandem, and so the linkage issue became moot.
But didn't the calls, they may not have expressly said they're connected, but as I read them, they said the first one must be completed and then the next one.
Yes.
That seems to, without using the words, suggest there's that relationship.
Absolutely. In the November 2nd call, the first Fidelity representative, I believe twice, said that the way the rollover would take place, with both components would be rolled over to the Fidelity retail accounts. And then once both of those were there, then the transfer to Goldman Sachs would take place. So he didn't use the word linkage, but he twice said both components have to be there. And what the panel, the appeals panel was looking at was not only did they say
You're not
that,
talking about us, right?
No, I'm not talking about, I'm talking about the Altria panel, that in fact, the two components did in fact roll over in tandem and were available together on November 12th, and only 3 business days, shorter than had been estimated. So that was the first principal ground. And is that a reasonable basis for denying the claim? Absolutely. Is that an abuse of discretion? Clearly not. But the second ground they had, which and wasn't addressed this morning, they also determined that Mr. Kelly had suffered no damages based on his damage theory that he presented to them. Because they said, under the best case scenario, Mr. Kelly, you would not have had access to the funds to send to Goldman Sachs before November 9th. So we're really talking about the alleged delay was between November 9th and November 12th. Well, you based your damages on the performance of the S&P 500, the SPY fund that tracks the S&P 500. You said you would have invested your money in that fund on November 9th. Well, that fund went down between November 9th and November 12th. So you had no damages to boot. So not only were you properly advised, there was no delay in the rollovers, you also suffered no damages.
Does that issue, I mean, I understand how your argument that relates to a reasonable review. Didn't the district court exclude the plaintiff's damages expert?
Yes, in the district court, the plaintiff proffered a new damage theory and proffered a damage expert who had not been proffered before Altria and was arguing a different theory of damages than had been presented to Altria.
And that was excluded
Yes,
under
sir.
702?
The district court excluded that expert in the new damage theory, and that was not challenged on this appeal.
Okay.
And then finally, Your Honors, on the conflict of interest, I want to make sure that you understand the record here. There was no conflict raised before Altria and the appeal panel. Now, you just heard they knew the grounds for it, that they knew Mr. Whitaker was going to be on this appeal panel. They didn't challenge it before the appeal panel. When they sued, their complaint didn't allege it. This was some after-the-fact conflict they conjured up in discovery. And, Your Honor, as the district court found, there was no there. There was no evidence of any bias. So it cannot be that Altria abused its discretion because of a purported conflict of interest that was never raised with Altria, and in fact, that has no factual basis. So, Your Honors, for those reasons, we ask that you affirm based on the very well-reasoned opinion of the district court on that claim.
On the claim of the document disclosure, I'm looking at the statutory language, which our opinion in Faircloth commands that we look at, and it seems pretty clear to me that the ASA is a contract under which the plan is operated. And particularly looking at the ASA itself, seems to fall squarely within that statutory definition, and I think at least two of our sister circuits have agreed that an ASA does fall within the document disclosure provision. So how can we distinguish those two circuit opinions?
Yes. You distinguish those opinions, Your Honor, because the contracts in both of those cases gave the third-party administrator discretionary responsibilities. And I think in both cases,
But how is the person requesting the document to know what the ASA says before they get it?
Well,
You're
but
right,
that-
you're right. If the document doesn't give any discretionary responsibilities, but it still is under which the plan is operated.
Yes.
I mean, the plan is operated under that ASA. And whether or not it gives discretionary responsibilities, that might go to the first issue, as Judge Benjamin pointed out, but that can't be known without looking at the document itself. And unless the individual requesting the document, which ERISA provides they're entitled to, has access to the document, then there's no way that they can know whether there's discretion or not.
Well, the 2 points there, if I might unpack them. First, on the statutory language about a contract under which the plan is operated. In Faircloth, this court held that what that means is it a contract under which the plan is managed or under which the affairs of the plan are directed, managed or direct the affairs. The contract doesn't give Fidelity any authority to manage or direct the affairs of the DPS plan. To the contrary, the contract expressly prohibits Fidelity from managing the plan. That is in Section 2.
No, but it definitely gives Fidelity the obligation to conduct the affairs of the plan. The individuals have to call Fidelity when they have a question. That's the number they call.
But that is not directing the affairs of the plan. And that is a hotline answering
Well, it's
consumer
conducting.
questions. You would not.
It might not be directing, but it certainly seems to be conducting.
No, Your Honor, the Section 2 of the contract, which appears on Joint Appendix page 1177 through 1178, I believe it's volume 5 of the appendix, expressly provides that the services that are given to Fidelity are directed nature and that Fidelity will not perform any service to be treated as an administrator or fiduciary of the plan. It goes on to say that nothing in this agreement is intended to give Fidelity any discretionary authority or any discretionary responsibility for the plan, and that Fidelity's role is that of a directed record keeper. Your Honor, it cannot fairly be said that Fidelity manages or directs the affairs of the plan when it is expressly barred from doing any of that. Fidelity has no authority or control over the key aspects of the plan, such as over the plan terms. It can amend them, add them, delete them, or interpret them. It has no authority to define who will be eligible participants in the plan, what the contribution requirements will be, either from the company or from the employees.
Did the ASAs in Mondry and MS contain those provisions?
I'm sorry, ma'am?
Did the ASAs in Mondry and MS contain those provisions?
I do not recall that the opinion says that the two opinions say that they do. The difference in those other cases, Your Honor, and I believe in each case that the third party provider in those cases was given authority over claims, discretionary authority, either to decide claims. For example, like in a healthcare plan, like you hire Blue Cross Blue Shield to administer the claims. Blue Cross Blue Shield sits in judgment on what claims are medically necessary and whether they'll be reimbursed. That type of discretionary authority, the claims administration, qualified as a contract under which the plan is operated. Likewise, in the Primera case, which is the principal case cited by the Mr. Kelly here, in that case, the administrator was given authority to adjudicate claims for denial of benefits. If there was a claim under Section 503 of ERISA for denial of benefits, Microsoft delegated the authority to that outside company to decide it.
So your argument is that the language of the statute essentially means that the document must involve an entity's discretionary authority before it's covered by the statute, even if it's, functionally and operationally a part of the, operation of the plan.
Well, that's right, Your Honor, and maybe an analogy might help. If a corporation opens up an account, bank accounts at Bank of America.
Hold on, I want to hear that, but I want to make sure I
Yes, sir.
understand the context of it. Because the statutory language doesn't say that. It says, well, I think we talked about managing and operating, managing and operating. You can operate something in a non-discretionary way. So it sounds like your argument hinges on the way that's been interpreted in fair cloth.
In part in that, Your Honor, but also I think that the maxim of, I forget the Latin term, but it's, you're known by the company you keep. If you look at the other documents that Section 104 concerns, it's the plan document. It's the trust that sets up the plan. It's the organic constituent documents that create the plan and decides who will control it. And so when it talks about the contracts under which a plan is established or operated, I think it's informed by the company and the other types of contracts Congress put, or documents Congress put into that statute. Look, if Congress had wanted to say 104 requires production of every contract that a plan enters into, or every contract for a service provider to the plan, it could have easily written the statute to say that. It didn't. It used that very particular phraseology about established or under which operated. And so that has to mean the types of discretionary authorities that these other types of instruments provide.
Do you have, let's assume hypothetically you're wrong there, and we think it's covered by the statute. Is there, Judge Berner asked earlier about a materiality issue. Is there any second-order question beyond whether it is or is not covered by the statute?
Well, I heard my colleague say that he believes it has to be material to his claim. It clearly is not material to his claim for the denial of the benefits. You look at all the briefing in the district court and here, he doesn't rely on that administrative services agreement at all to say that there was an abuse of discretion.
Look, my question, though, is as a matter of law, regardless of what's argued here, is there authority that there's a second-order question about materiality or anything else?
I think there are second-order questions about materiality and
where's that come from?
I think in the discretion, if it bears in terms of like what relief the district court will provide, I think the issue was on the penalty question.
Okay,
it bears on that.
If there's a violation, then it bears on whether there's a penalty. It doesn't bear on whether it's a violation. Is that?
I think that's right, Your Honor. But if I may make one last comment, I realize my time is out, but if you want to see who does manage or operate the plan, that is described in Article 10 of the plan document. It appears on Joint Appendix, page 364 in the first volume. It lists there the plan administrator, the investment committee, the monitoring committee, the management committee, and the Altria stock and non-stock independent fiduciaries. Who is missing from that list of administrators? Fidelity. That is a reflection that Fidelity does not operate, manage, or direct the affairs of the plan. Thank you, Your Honors.
Mr. Field?
Good morning, Your Honors. May it please the Court. Eric Field on behalf of Fidelity. I'll primarily just stick to the fiduciary breach questions, as that's the only claim that's directed at Fidelity. And as the Court has already recognized that Fidelity can only be a fiduciary if it has discretion. And in this case, under the contract, under the plan, and under prior decisions of this Court and other courts, a record keeper that just performs ministerial functions cannot be a fiduciary because it has no discretion.
Your friend on the other side says that this is a question of fact and that on summary judgment, it was appropriate to take all inferences in favor of the non-moving party and therefore summary judgment was inappropriate. Why isn't that right?
Because there's no contested material fact here, Your Honor. It's all in the transcript. If you read the transcript, and if you read the documents that are all part of the record already, the document, the ASA, most importantly, says that not only is Fidelity not a fiduciary, it cannot take any actions under the contract that would make it a fiduciary.
But even if the contract says no fiduciary, they're not allowed to be a fiduciary, there's no obligation that that your client be a fiduciary, isn't it possible that in conversation on the phone, the Fidelity representative could give advice in violation of the ASA, but give advice, and that the individual calling could reasonably believe that they were being given advice and follow that advice? And so is it possible as a matter of law that Fidelity could act as a fiduciary even if the contractual agreement didn't provide the authority to act as a fiduciary?
If you read the transcript, that isn't what occurred. Is it possible if Fidelity had taken the steps to say we are giving you advice and we're directing you how to do this,
Do they have to actually use the words, "we're giving you advice"? What if they just give advice?
But if, under the transcript, that isn't what occurred.
We're just trying, but as a matter of law, the fact that you put it in writing that you're not doesn't give you a get-out-of-jail-free card if you, in fact, proceed to act as a fiduciary. Do you agree with that as a matter of law?
If you go beyond what the contract provides and take this next step to act as a function of fiduciary towards limited actions, yes, you could talk yourself into being a fiduciary. But that is not what has happened here. When you read the transcript, it was Mr. Kelly who called and said, I want to have my account distributed. The caller, on the first November 2nd call, first said to him, okay, the process will be, because you want to do an in-kind distribution and you want to do a cash distribution of the index fund and the Altria shares, we will liquidate those shares to cash and we will mail you a check. At the same time, we will mail you your stock certificates. So you're going to get everything in the mail, and that'll take 1 to 2 weeks. It was Mr. Kelly and his advisors who then said, oh, we don't want to use the mail. Is there another option? So they weren't giving him advice. They weren't volunteering, here are all these options you have. It was Mr. Kelly who said, is there another way we can do this?
Do you, I think I understand your argument there. I just want to, again, have a kind of structural point. Do you agree that unlike the review of the disability denial, that this is a straight Rule 56, is there a genuine issue of material fact, construing the evidence in the light most favorable to Mr. Kelly?
I do agree, Your Honor.
I know you think you win nonetheless,
Well,
but that's our standard.
That is your standard. Is there a genuine issue of material fact? And here, because we have the contracts, we have the plan document, and we have the transcript, there is no other facts that are going to come out that is going to change the equation. We would just be back and there is no jury trial because in the ERISA case, we'd be back before the same court on the same identical record that he's already found didn't support a finding that Fidelity was a fiduciary. So we've already really been through this process.
So even though they're cross motions of summary judgment, well, that's an interesting procedural issue. It's cross motions for summary judgment, but this is a non-jury trial. And so even though we're under Rule 56, practically the courts had all the information. I may ask your colleague about that.
In an ERISA case, it's typically going to be decided on summary judgment because it's an administrative record case.
Right.
There is no live testimony, there is no jury, so everything that's going to be needed to decide the case is already before the court on the summary judgment. So there was really no point to go back, even because any material fact has already been reviewed by the court, and he's already decided that there is nothing left for me to do because the transcript, as I said, makes clear what happened here. Fidelity was asked, what are my options? Here are your options. They did not tell him which one was better. In fact, the first option they said was, we'll mail it to you. Even after that, when Mr. Kelly asked, well, could I split the transactions and do the cash distribution separate from the in-kind? And they said you could, but then you would still have to take the cash distribution in a check through the mail, which Mr. Kelly had said, well, I don't want to take it through the mail. That's when they would said, okay, well, then your option is to use the Fidelity retail accounts.
Okay.
And that's how it's going to work.
You're over time. Any other questions,
No.
Judge Brown? Thank
Thank
you.
you.
Mr. Hawkins?
Thank you, Your Honor. When I was in law school, I got up in rebuttal once and said, I have 13 arguments to rebut, and we're not going to do that today. That didn't go well either. To reference what Your Honor was just talking about with the breach of fiduciary duty claim, I would analogize it to a de novo review, if you want to think of it that way, and this court's Techman decision would control any kind of analysis. The court below made no findings of fact or conclusions of law, and that's what it would have had to have done if it were acting as a finder of fact for a non-jury trial case.
Fair enough, but I mean,
And they'd be entitled to much more strong weight.
what do you mean much more strong way?
They would be given much more deference if Judge Hudson had issued findings of fact and conclusions of law. The findings of fact would be, reviewed for clear error.
I hear you, but you don't have any other evidence. There's no more evidence to be considered than what was before the district court.
Well, yes, the items that were not before the district court were the audio files of all of the calls. And I think the transcript is informative, but it is not dispositive. And I think the audio of all of the calls, which does exist, would have been important.
Would the calls made after your client made his decision be relevant?
Yes.
Why is that?
Well, for two reasons. One, the November 10th call in particular and the November 9th call, Fidelity admits, they acknowledge that the linkage issue was not conveyed. They explain it in clear terms in a way that was never done before, and I think the contrast there is probative of what Mr. Kelly was not told on November 2nd, November 5th. And to go to the November 5th issue, because Mr. Schabelsky, and it's a common theme, wants to say that everything gets wiped away on November 5th, but that ignores the November 2nd issue.
Well,
if he'd been given all of the information, he would never have needed to get to November 5th.
I guess it just strikes me that there's no obligation to give all of this information if Fidelity's not acting, is not a fiduciary. So your threshold issue is whether Fidelity is a fiduciary in the first place.
I
and because
completely
the-
agree with you.
Let me ask my question. Because the agreement itself does not seem to grant any fiduciary obligations, you're really resting on whether the call center individual was acting as a fiduciary as a matter of fact. And so you seem to be arguing against yourself when on the one hand you're saying they didn't provide all the information, and on the other hand you're saying they provided so much information that they stepped into the shoes of a fiduciary.
Well, a fiduciary, and this court's Griggs decision makes this clear, a fiduciary can do just as much damage by not providing information.
But only if they're a fiduciary.
Absolutely, absolutely.
So how do they become a fiduciary when they're simply setting out the options of what your client can or cannot do?
Well, they know what he is trying to accomplish, and they are assisting him in that regard. And it's our position that that assistance crossed the line and turned them into a fiduciary. And once that happened, all of the duties that rest upon a fiduciary come to play. I see my time is up.
I have one more question. Do you, in the discussion earlier, your colleague talked about how the board relied on the lack of damages.
Correct.
And how that was part of the decision. And then, I asked about your damages theory at trial, and the court excluded that. Even if we were to agree with you on the other, if your expert testimony has been excluded, how is there any recovery available under the first two counts?
Well, the first count is Altria's evidence proves the damages. Altria's own internal PowerPoint, pages 17 and 18.
So you think you
And they
can-
never, I'm
Go
sorry.
ahead. So you think you come in with a theory of damages, have an expert on that, the expert's been excluded, and you still can produce damages some other way?
Okay, we've got two different counts. So the count
Right.
one claim is the administrative review. And when we get the denial, the very first denial, it doesn't say anything about the fact that you don't have any damages. That first, August 1st, 2022 letter. So we respond and say, breach of duties, and here's the damages. And that's when we first get word from Altria in their response, oh, well, you didn't suffer any damages anyway. We've never had a chance to rebut that or discuss that at the administrative level, and that's the failure of the full and fair review. And that's why their evidence, their own internal evidence of what Mr. Kelly would have gained if they had addressed his theory is so important. We would have gone back and forth. Now, for the breach of fiduciary duty claim, we saw equitable relief, and there's a float that Fidelity has, and we were arguing for a disgorgement of the arguments there. That's more evidence that would have been presented, regardless of our damages expert. And I don't think he should have been excluded, but there was never a motion on that. But I thank you for the court. I do want to make.
Just a second. Any other questions? No. Thank you, counsel.
If I may, the
Yeah,
attorney's fees, we never talked about it. If your honors reverse on any of the first two claims, it should be vacated. We also think it is a colossal abuse of discretion and should never have been awarded in the first place. Thank you.
Thank you. All right, we'll come down and greet counsel, take this matter under advisement, and move on to our next case. Our second case is case number 252320. We'll hear from the petitioner. I think, yeah, that's right.
Yes,
Counsel.
good morning. My name is Megan Herndon of Murray Osorio. Thank you very much for having me here today. I represent petitioner Claudia Oriana and her children. May it please the court, petitioner Claudia Oriana's case presents a single issue: whether the threats and harm she faced were on account of her familial relationship, the protected ground for asylum in this case. Petitioners do not ask this court to alter or expand case law, just to order the agency to apply existing jurisprudence. In the decision below, the agency made the same error this court has recognized before: an incorrect focus on why a persecutor harmed someone other than the applicant in question. And here, petitioner presented evidence so compelling that no reasonable adjudicator could fail to find the elements required for asylum, in this case, that her persecution was on account of her nuclear family-based particular social group. The agency made a legal error when it incorrectly focused on why her persecutor, Franklin Conjura, harmed her partner, Nuan Rogel, while evidence in the record compels the conclusion that one central reason, if not the only reason, Ms. Oriana was persecuted was her familial relationship with her partner, Nuan, the father of her 2 children.
So, counsel, if we agree with you, what should we do?
Your Honor, if you agree, the recourse would be remand to the board.
Okay, and would the board be able to consider issues other than nexus?
I don't see why not, Your Honor, and in this regard, I think that respondents make too much of issues that are really not properly before the court. In this case, respondents' counterstatement of the issues is quite telling in this regard, where it attempts to shift the focus to whether she was harmed in the past because she was directly and clearly threatened by death by an aggressive armed...
Well, the immigration judge said that you had not shown that you could that you would be damaged if you, or persecuted if you relocated. The board didn't address that issue. I'm simply asking that issue and whether, there's controversy or AG opinions about the family group as a particular social group. There's unwilling and unable. There are a number of issues that would be fair game if this case were to be vacated and sent back. Do you agree with that?
I do, Your Honor. I would like to talk a little bit more about the nexus here. The agency denied asylum on the theory that the basis for Ms. Oriana's harm was a personal dispute, and there was a personal dispute here. But the existence of a personal dispute between a persecutor and some party other than the applicant does not negate the possibility of persecutory motive for harming the asylum applicant. Take, for example, what if the persecutor here, Franklin, was enraged by the same extramarital affair, and instead of harming Ms. Oriana and her family, he misplaced his rage into a race-based rage and misdirected his anger at a person who shared the same race as the person who had the extramarital affair, but no other prior connection, no other prior involvement. I think that it's important that the court recognize that all of the 5 protected grounds in the statute share equal footing as a matter of statute, and that it seems like if you had a corollary between some of the other protected grounds, it would be even clearer that this is that this is a family-based nexus, not something outside of the statute's reach.
But you don't disagree that the dispute between Non and Mr. Kenora was a personal dispute?
Not at all. I believe that is a personal dispute. It's simply the focus, the agency misplaced the focus on why the applicant for asylum in question was harmed, not whether somewhere in the fact pattern of the case there was a personal dispute.
Does it make, I'm familiar with our cases and understand your argument and think there's some support for it. Does it matter, though, in deciding whether this was on account of being part of the nuclear family with the guy who had the affair? I'm drawing a blank on the name, I'm sorry. Does the fact that this the record appears to show that he was coming for 3 days, 4 times a day, and, it was intense, and he certainly mentioned the family, when he did that. But does the fact that that the record doesn't show continued threats, and I'm not really trying to get this into this record, but if you have a case that's very short-lived in terms of the threats and persecution, when the claim against the initial the partner was a personal matter, does that somehow inform whether this is really on account of being the nuclear relationship? It just seems like that a short-lived dispute somehow informs the nexus question. I didn't see a case that said that, and maybe I'm wrong about that. Am I making any sense to you?
Of course, Your Honor, and I think that there's different areas that the law would inform on this, but I believe that the really central issue here is that we have not just circumstantial evidence that there was a nuclear family-based harm, we have the direct testimony.
Yeah, he said it.
And I think in a lot of cases you have issues that are a bit more reliant on circumstantial evidence. Like in Cruz, the court found it compelling evidence of the on account of factor, the nexus factor, that the threats were made in the family home, the center of the family. I think that a lot of the work that the asylum law does that you're getting at, Your Honor, works in areas other than nexus.
Yeah,
So I think this goes back to your initial point. Yeah, there could be some other issues on remand, whether by the board or after further remand and fact-finding to the court. But when we're focused on the real sole issue that the board decided here, it is just compelling, and we have the direct, persuasive, credible testimony of Ms. Oriana that every time he would always threaten, he always said family.
So, kind of back to assuming we agree with you, in the past, I think if you look at our cases, if we find a problem, we vacate, and as you acknowledge, other issues can be considered. I'm not sure we have a case since, and this, I hope this doesn't come out of left field, but maybe it is a little bit. But yeah, the Supreme Court's recent White Lion case, I don't know if you're familiar with it, and I'm not trying to catch a cold, but it deals with the conflict between, or tension between Chenery, which says we can't affirm an agency decision on the ground that it didn't base its decision on, with the APA's harmless error statute. And it kind of talks about how, we can give some consideration to White, to issue that the agency didn't decide if it was sufficiently clear. First of all, do you have a thought about whether any reason White Lion wouldn't apply to immigration appeals?
Well, with respect, Your Honor, I think in order to give most fulsome consideration to this, I would have to review and would offer to provide a 28J letter.
Yeah,
But-
the government hasn't raised it, so I'm not sure. I think it would be subject to forfeiture. I'm just trying to understand as a, first principles matter. If you're not prepared to talk about it, I totally respect that. But it seems like that would apply here at least.
I think Chenery is really dispositive here. I think you have an issue where the immigration court had many, many issues that it could have addressed.
But White Lion clearly changes or, informs how we do what would previously been Chenery. So, I mean, as a general matter, White Lion alters that analysis. Now, whether it does it, maybe you claim it doesn't apply here.
Well, I'm not sure I can fully speak to that today, but I think especially with regards to protection claims, which this court has recognized derived from important statutory protections, we know also that respondents are what we call the applicants in immigration proceedings. So applicants in immigration proceedings, they have a fundamental due process claim, a fundamental due process to a full hearing. Here, Ms. Oriana appeared without counsel. The judge developed the record. Could the judge have developed the record more if she wanted to get to certain other issues? Absolutely, but of course you have a court that has an overwhelming number of cases before it. The board had the opportunity to address multiple issues. It chose to address this one. And I believe that under Chenery, there really should be no option other than to remand. I think that the record below is insufficient for the court to rule on other issues.
Let me ask you, so you, in your brief cite, the gang-related cases and the behavior there, and I guess kind of analogizes that to what's here, because there's no conflict between, there's no personal relationship between, I think it was Mr. Conjura and the claimant here, Ms. Oriana. So how do you, how do you distinguish your, is that what you would argue, right? Is that it's more like the gang-related cases in Hernandez and than Toledo and Velasquez, which you said is a personal?
Yes, this is more like Sosa. It's more like Hernandez Vasquez and the other cases than Toledo Vasquez and Velasquez. Those were Velasquez and Toledo Vasquez. There were very specific factual findings as to another central reason for the persecution. Here, where Ms. Oriana had no prior relationship with her persecutor, the evidence really is extremely compelling and very, very factually different from some of these other cases where there was another interaction. And as to the gang-related element, I know that the government in its brief noted that unlike in some of the other cases where this court had found nexus, the persecutor was a gang member. Here, there's no indication that the persecutor is a gang member, but I don't think that the statute makes any difference in that. So I think if we go back to the statutory language, as to who the persecutor is, it makes no difference whether the persecutor is a member of the government, is a gang member, or another private actor. Of course, many of the other sections of the statute may do some work into whether the person ultimately is entitled to relief, but I think that it's a bit of a red herring to suggest that that an individual who is persecuted in the same manner by a gang member might deserve relief, and someone who is persecuted in the same manner by a non-gang member does not. I don't think the statute really calls for that distinction. Your Honors, I would just reiterate that this is a single issue case, and that the agency misapplied the law. By misapplying the law, it abused its discretion. The record here, the facts are extremely compelling and very different from many of the other cases, in that the immigration judge found no separate reason why there could be persecution here. In fact, the immigration judge found each time that Franklin Conjura was armed, and each time he threatened the family. That's at Joint Appendix 94.
And on the credibility issue, the immigration judge also found your client credible, isn't that right?
Yes, Your Honor, credible and persuasive, and there was some other language there that was that left no doubt as to the weight to be given to her testimony. Unless Your Honors have other questions, I will see the minute that I have left.
Thank you, counsel.
Thank you.
We'll now hear from the government.
Good morning.
Good morning.
Kristen Jafrida for the government. Happy to be here. This case is about nexus. And in such a case, the applicant has the burden to establish three connected things. and that's harm or the threat of harm on the one hand, the protected ground, and the connection between the two, which is motive. And that proof of motive, which the Supreme Court in Elias called critical. And in this case, the immigration judge made a factual finding, which this court has said that the nexus is a classic factual determination, that the motive for any harm that Ms. Orellana experienced or feared was a personal dispute and not her particular social group, family members of her former partner. And the board affirmed that finding and that she did not establish that any harm she feared was
Well, how
on
do
account
you
of the-
explain that she did not have any personal dispute with Mr. Kanjar? Her husband is the one that had a personal dispute.
But she, and the factual finding that they made was she didn't have any dispute at all. In fact, she never spoke to Mr. Kanjura. He never spoke to her at all. And he never threatened her at all. He never harmed her, he never threatened her. And the board, you can find those in the record, her testimony at around the record at around 167, where all of the threats were made directly to her former partner. And during those threats, he said, he always said, this is a quote, he always said that because of him, his children were going to pay the price.
Well,
And that
I mean,
is
she
the-
heard it, right? I mean, assume
She
you,
heard it, but that's the sum total of the evidence of motive, which the government submits as far from compelling evidence of a threat that amounts to persecution.
well, that's, so if I could make sure I understand you, I mean, one issue would be whether the petitioner has been persecuted. I mean, and that's an argument that it could be made. But the question, the board didn't decide that. The board said there was no nexus.
Well,
Okay, let me just finish. And so, yeah, there may be a number of issues, but on nexus, yeah, our court's been quite expansive on how we viewed nexus. I've been on the other
Where?
side of some of those, cases, but our precedent's our precedent.
Right.
And what it asks is whether the petitioner, ask us to look at whether the petitioner is persecuted as opposed to anyone else in society based on that family relationship. And whether it rises to persecution or not, how is what happened to the petitioner here not on account of her family relationship?
there's a difference between identifying the protected ground, the family, and the harm, you have to say, and the threat of harm. And the immigration judge has to look at what the evidence she's giving and discern what the motive is. And this is what her testimony was, which I just quoted to you. So in there, he has to find what is her proof of what the motive is. And that proof was that he never spoke to me, he pushed me once, and this is what he said to my partner. So she has identified the protected ground, family. He made these threats to my partner. He mentioned family. So what is the motive? And they said, it's the personal dispute. So is it incidental, subordinate, tangential, this family relationship? And that is what the immigration judge found. So is there compelling evidence that her family relationship was a central motive there?
But
And I
what is
think-
the motive other than her family relationship? I mean, I'm really struggling
It
to.
was the personal dispute.
Well, it was the personal dispute, as your colleague on the other side conceded, is between the two men. But the motive for.
There was no
excuse
motive
me, the
to harm
motive.
her at all.
Let her finish asking her question.
sorry.
That might help, answer it better.
So I think there's agreement between you and counsel for the petitioner that there was a personal dispute between the two men. The argument is that the motive for the threats against the petitioner, were the relationship between herself and the father of her children. That is that is a familial relationship, is it not?
There's a familiar relationship between her and the father of her children, yes.
And the argument is that the threat was because of the relationship. She was being threatened because the father of her children that somebody had taken offense at something the father of her children had done. And so the threats and her fear of persecution is on the basis, as her argument goes, of her familial relationship.
To the extent that she was included in those threats to the family members, if that,
So why is that not a sufficient nexus to her familial relationship?
it could be, well, for two reasons. I mean, this court has a line of authority, as does every other circuit, that says these kinds of disputes fall entirely outside of the rubric of what constitutes persecution.
What
And those
cases are those?
Velasquez and Toledo Vasquez. It says these personal disputes or ordinary crimes
So-
are not persecution.
I know a little bit about Toledo Vasquez, I wrote it.
Yes.
And there, that was a situation where a sister assisted her sister who was being abused, treated horribly, by the sister's husband. And the evidence was that every time she was persecuted, it was because she was helping her sister. And the evidence was that that people other than her family members also helped her sister, and they were also persecuted. And so it seems like, for sure, we have cases where we say that a central reason was not the family relationship. But it seems, but comparing that case to this case, there was no evidence that I'm aware of that, that the man threatened anyone other than the partner and his family members.
Well, and in Velasquez, where it was this personal dispute between the mother-in-law and the woman over the custody dispute.
Yeah.
But those seem like
Also-
those are intrafamilial type disputes, that she doesn't have a dispute with, you would agree, she has no dispute with, personal dispute herself with Corian.
Well,
It's her
these-
they has a dispute with him,
Right.
and he is not a member of their family.
But they're also like two families, that they are connected in Velasquez, the mother-in-law, and in this case, it's also two families. But they are the same, they are more alike than the gang cases, in that it's just a purely personal matter, with, no connection to any sort of state action, because this circuit also has case law, as does every other circuit, that says inherent in persecution is state action or action by private parties that the state is unwilling or unable to control.
Sure, and that may be a great issue for you, but that's not what the decision was. I mean, I think you got a number of issues that, from my review, appear strong. I mean, the unwilling and unable issue, I think that looks very strong. I think the threat of future persecution, when this lasted for 3 or 4 days, and, there was no continued persecution afterwards. There are a number of grounds, but when we get a decision from the board that's talking about nexus, that's, unless my white lion, kind of argument is something to think about, which you haven't briefed, then, and I don't blame you for that, that's very new. I hope that's not a criticism.
No.
We only got one issue here, and we got, a lot of cases that seem to make your argument difficult to square with our precedent.
But, sure, but even Hernandez-Avalos, it says that not every case that involves a family is
Sure.
going to involve that nexus. And she does have to prove that it was a central reason and not a subordinate or incidental or tangential reason. And just
But when we
because
say-
she's related to this, I mean, if there's, no need to even look at the record and look at, what went on, if every time someone, you have a crazy neighbor that says, if your kid keeps beating up my kid in school and I'm gonna kill you and him, then that's a matter for international refugee protection. Or if your dog keeps relieving itself on my lawn and I'm gonna kill your whole family, that's a matter for, it seems that, those are personal matters and not a
So,
matter for asylum and
so
withholding of
is it,
removal.
is it
That-
your position then that if part of the persecutor's motive is a personal dispute, then the asylum claim necessarily fails? Is that your argument?
I think it depends on what the record says. I think you need to examine the record and look at, what the actual evidence is. And to apply your nexus test in a way that's consistent with Supreme Court precedent and with the statute. And whether it's incidental, subordinate, tangential, and and your own precedent in Vasquez to see whether it is a personal dispute. That, in a way that makes sense, that doesn't lead to results that are, unnatural and absurd. And like the examples that I just gave, to whether someone's having an illicit sexual affair that is, obviously something that.
Are you asking-
Every human interaction is not a matter for.
So, and
of
that.
the asylum statute.
Counsel, I mean, I think I understand where you're going with that, but you said apply our precedent. And it seems to me like you're asking us to go in bank and refine our precedent, because if our precedent says that a familial relationship is a central reason for persecution, if that relationship is the reason the petitioner is persecuted as opposed to other members of society, it's enough. And that rule is very broad and may lead to results like the one you're talking about, I think. And so it seems to me like your argument is with our rule, and that may be a good argument, but it's not an argument that three of us can do anything about.
No, I
You agree with
understand. I don't think you have to. I think in my brief, I showed a way that you could rule in this case along the lines of Vasquez and Toledo Vasquez that distinguishes Hernandez-Avalos and Salgado Sosa. That follows those other cases in personal dispute and on those types of cases as opposed to Hernandez-Avalos. And I think you can, in this case, because of the record and the scant evidence in the record of motive, the actual evidence that, the testimony is about 2 paragraphs long, and that there isn't compelling evidence in the record of motives. And where there are two, where the record plausibly supports, 2 results, and the one the agency chooses and the one petitioner advances, defer to the agency's construction or choice in that regard.
Do you have a position on the questions I asked your colleague about White Lion and whether that allows us to,
Right.
deny a petition from an from an immigration-related agency if the standard for that case is met?
I confess I haven't read White Lion, and
Okay.
and just the same, I would submit a 28-J letter, but I would say that, just the harmless error principles would apply because there's plenty of reasons to deny relief in this case, frankly. So,
Well, the good with the white lion is that it does that. The bad is they denied it because it had been forfeited, and,
Yeah.
so I'm not,
Yeah.
again, critical of that because it's new, but,
Right.
anyway, I appreciate that.
thank you very much.
Hold a second, any
oh,
other
you have any
questions?
Oh, no.
Thank you,
I
counsel.
would also just say briefly that this is probably going to be my last argument on behalf of DOJ, and so I would just thank counsel and the court and
Thank you.
say that it's been a great honor to argue in the courts of the United States.
Thank you. Appreciate your work and service.
Your Honors, the applicant for asylum, Ms. Petitioner Ms. Oriana, provided what the immigration judge described as credible, responsive, candid, plausible, and detailed testimony. That's at Joint Appendix 75 to 76. Finding that Ms. Oriana was harmed as a result of a personal dispute lacked substantial evidence. It failed to consider the court's jurisprudence on the nexus from this court's case, and there is no occasion to depart from it here. My colleague's example of a neighbor's dog does not consider the other prongs of the asylum statute, and that explains why those facts themselves might fall short and seem to not qualify. I would submit to this court that if person A goes up to person B and, through credible, responsive, candid, plausible, and detailed evidence, says, I am going to kill your family for what you did, that is family-based nexus under this court's jurisprudence.
So would you agree that under the examples your colleague mentioned, that nexus would be established? Is that your position?
I'm sorry, Your Honor, which examples?
The two hypotheticals that she said, affirming would lead to kind of the things she said were kind of, a neighbor who's doing bizarre stuff or a dog who's doing bizarre stuff. You said there are the other factors that would be considered. Fair enough, but is your position that on nexus alone, that would satisfy the law?
It could. The dog example, I don't think has sufficient facts for me to comment, but take, for example, on the two neighbors. What if the two neighbors were the Hatfields and the McCoys, and you had record evidence of a family-based dispute and really no other issue, no personal dispute other than the fact that these two families were in a long feud?
I think that's her argument, that we don't have a Hatfield and McCoy sort of situation. We got an isolated incident that led to these threats, and it sounds like your argument would be in those hypotheticals, you may have a problem with other issues, but you don't have a problem with nexus.
I think you don't necessarily have a problem with nexus. If the evidence is person A is going to kill person B in one central reason because of their family nexus, you have nexus. Thank you, Your Honors.
Thank you. Thanks both counsel, and we'll come down to Greek counsel and take this matter under advisement and move to our final case.
We need a break.
You okay to keep going? All right, great. United States of America versus Carson. We'll hear from you, Ms. Baldwin.
Good morning, Your Honors. May it please the court. Melissa Baldwin on behalf of the appellant Jermaine Carson. We are asking this court to reverse the district court's denial of the motion to suppress. Agent Cortell, without reasonable suspicion, detoured from Washington's suspended license investigation by researching the criminal history of the Highlander and its registered owner. This prolongation provided Hayes with a window to observe facts supplying probable cause that resulted in the firearms discovery. This was a violation of Rodriguez and Mr. Carson's Fourth Amendment rights and should have resulted in granting the suppression motion. So first, starting to Agent Cortell's detour in his patrol car, where he admitted to researching both the Highlander's involvement in any past crimes and the registered owner's criminal history. Neither one of these related to the suspended license investigation itself, nor was it an ordinary inquiry incidental to that investigation under Rodriguez.
Well, why not?
Well, the ordinary incidents in a traffic stop must have a close connection to roadway safety, and in this case, the fact that the Highlander may have been used in a past crime has no impact on whether or not it can be operated safely.
What if it was hijacked that day?
If it was hijacked that day, the fact it was hijacked, the fact someone hijacked it might suggest criminal activity or danger, but the mere fact a car was involved. So if Agent Cortell had some reason to suspect that this car was hijacked, I think that would be a different case.
It would be, yeah, but doesn't Rodriguez specifically allow an officer to check proof of insurance and registration? It mentions those things specifically, right?
It does, and we have, I believe, Agent Cortell acknowledged he did that in addition to looking at the vehicle's involvement in any past crimes.
I guess my point is that one, I don't think Rodriguez talked about those being the only things, and I'm just curious as to why, if that I mentioned the car being hijacked, or if there was evidence that if he's considering officer safety, if the car had been part of a recent crime. You said it'd been a long time, it could have been one a long time ago, maybe true, but you don't know that on the front end. What if it had been involved in a crime earlier that morning?
Well, officer safety is a different category than the ordinary incident. So my understanding based on Rodriguez is the ordinary incidents are categorically allowed in any and all traffic stops, versus officer safety in this court's recent decision by Judge Benjamin in Martin, a officer safety measure, the facts have to show that the safety concern warrants those measures in that particular case. And so here, again, we have Agent Cortell had no reason to suspect that this car was recently hijacked. The only thing they knew was Mr. Washington was operating on a suspended license and was complying with the officer's demands. And so on those facts, officer safety was not involved. But
let me ask you this, though, because I think, just as a follow-up to Judge Quattlebaum, I think Rodriguez, but doesn't Rodriguez says that unrelated inquiries do not measurably extend. So how is this measurably extended? Because I think the time between when, I'm gonna get all the officers' name, Cortell is in the car running the license, or it's like 30 seconds, because it all kind of seems like it happens simultaneously. Hayes is at the car when he says he smells the marijuana. So how is that not measurably extended? Or why is that measurably extended, I should ask?
My understanding of Rodriguez is there is no de minimis exception. So if the officer safety measure is not, reasonably permitted under the facts of the case, even if it was a millisecond, Rodriguez is violated at that point because a seizure is the product of unreasonable delay at that point. So in this case, we know Cortell was in his car for, I believe it was 30 seconds before Hayes, testified he detected the marijuana odor.
And Cortell is saying that he has to do this before he can even start looking, I guess, into what you would consider criminal activity, he has to do his duo, I guess that we have duo mobile, but this two-step authentication. So he's trying to do that during this time. And so I'm just curious as to what the extension is that you find, because we don't exactly know when. I guess he starts suspecting the criminal activities. I think he speaks to the other officer who says, no, we can't call the dogs because we don't have any reasonable suspicion. But by that time, Hayes is already at the car and smells, based on the timing, and it's smelled the marijuana, right?
Right. By the time Cortell is discussing the drug dog with DeStefano, we would concede Hayes has detected the marijuana odor. But as regards to the timeline, you're correct. We don't have a precise millisecond pinpoint when it was delayed. We say, and that's because the government did not present a timeline of Cortell's actions in the patrol car. So all the government established was that Cortell, when he departed the stop at 11:25:22, he proceeded to engage in inquiries that were unrelated to the stop and prolonged it under Rodriguez.
Counsel, can I, to follow up on your answer and Judge Benjamin's question, as I understand it, you've got three aspects of what you claim to be a detour. There's the checking the vehicle history, there's checking the owner's history, and then there's the inquiry about the dog sniff. Is what you just said that Officer Hayes had smelled marijuana by the time of the dog sniff, does that make that detour moot or harmless or non-impactful here?
Well, I think the dog sniff still represents a Rodriguez violation because...
I gotcha, but if he's already smelled marijuana, and the timeline seems to show that, it seems like that, whether it is or it is not, is kind of beside the point. Tell me why I'm wrong on that.
So, well, at that point, I think that the remedial question becomes more difficult, but I think the government's forfeiture of inevitable discovery would come into play here, where the government did not raise inevitable discovery either in the district court or in this court.
Wasn't that a separate issue? I mean, waiver aside, I mean, in terms of whether the dog sniff question, represented a Rodriguez violation, doesn't it, how can you have that if there was a separate basis for, asking, Washington or Carson to get out the car and proceed in that direction if they've already smelled marijuana?
Well, I think it's a problem because of three reasons. The first, the point established was only that Hayes could have extended the stop when he detected marijuana. We know he didn't. We know he talked about candy at the car. And then secondly, and that goes to Rodriguez, where we have this dead time in the stop then, where, Mr. Hayes is engaging in small talk with the driver and not investigating the crime for which he has suspicion, while Officer Cortell is simultaneously not investigating. So we have this dead period of time where no officer is investigating criminal activity they have justifiable suspicion for, yet these motorists are detained on the side of the road.
No, I thought Hayes testified that he immediately smelled marijuana when he walked up to the car.
He did, but he did not proceed to investigate or do anything to verify or to verify or dispel that suspicion. Instead, he engaged in small talk with Mr. Washington. And then the third reason, the fact that Hayes merely could have extended the stop, that is just one part of the inevitable discovery doctrine. So if that showing alone wouldn't even justify an exception to the exclusionary rule, I don't see how it could then remedy the fact that there was this dead time where, one officer was engaged in a fishing expedition and another officer wasn't investigating the crime for which he suspected. So those would be like the three of the reasons why I think the drug sniff is still a problem, but I agree, I think the remedial issue goes away when you look at the earlier detours. And so we've talked a little bit about the vehicle's criminal history, but I also want to address the registered owner's criminal history. And in that case, I think In that case, again, there's no ordinary incident or officer safety measure because Agent Cortell did not know the registered owner was present in the vehicle when he ran that stop. So the fact I lend my car to a friend, the fact I may have a prior, arrest or felony conviction doesn't tell the officer anything about whether or not my car can be safely driven or whether or not he is facing a risk at a traffic stop that I'm not present in. And it wasn't cited in our brief, but I noticed it as I was rewatching the videos. If you look at Officer DiStefano's body-worn camera after the search at 11:41:38, Agent Cortell admits he didn't know the registered owner was present in the car. He asked Mr. Washington, does your girlfriend or wife or whoever that is, referring to the female passenger, have a license? So he's acknowledged that he was just engaged in a fishing expedition. He was looking for a reason to expand the stop when he was looking up the registered owner's criminal history. There was no reason to think it had anything to do with Mr. Washington's suspended license or, any safety issues that may have been present at the stop.
I thought the record showed that Corthell, or I may be pronouncing that wrong, recognized when the officer went to the car and was doing the check. Now, you challenged what he was doing, but in the process of doing that, realized that who he just saw in the car was consistent with what he saw in the ownership records.
I believe his testimony at Tor was he thought the register owner matched or closely matched, but I think the body-worn camera contradicts the notion that he recognized in that moment that the female passenger was the registered owner because he acknowledges on the body-worn camera he does not know who she is or whether or not she has a license.
Yeah, it was once he got information about the owner that he then matched up with what he had just seen.
He had already run that inquiry when he had made the admission saying, who is that? Does she have a license? So I think that showed.
Who said that? What officer said that?
Agent Cortell.
Okay.
So based on, if there are no further questions on the seizure, then I will move on to the frisk. If you agree that there was, a Rodriguez violation warranting, that warrants reversing the denial of the motion to suppress, you don't have to reach this issue, but if you disagree with us, then, Mr. Carson's frisk remain live. We've made an argument that there is reason that the Psaki presumption has been undermined and that, marijuana no longer presents the dangerousness that might have been present when it was first announced.
But we are bound by that decision, are we not?
So you are bound if there isn't, one of the exceptions, like the rationale being undermined applies. So, we've argued that exception, that there is, grounds for which you can find Psaki's rationale has been undermined. I acknowledge it's weak and it's probably more prudent to go en banc, but I made the argument. But that said.
We also have the Rooks case, this court's case in Rooks that says that if there's some suspicion of drugs that they can pat down.
Right, well, I'm not sure, I'm sorry, I can't recall if Rooks involved marijuana because ours is limited to marijuana, which I think
is illegal drugs.
So our challenge to Psaki would be limited to marijuana as opposed to drugs generally, and we think Psaki did get it wrong essentially, and it's inconsistent with Fourth Amendment jurisprudence, which generally requires case-specific findings to warrant intrusions. I mean, the Supreme Court's recent decision in the Lang case, where it rejected a categorical rule that police can always pursue a fleeing misdemeanor into home, they rejected it because, listen, it might be the case that that's usually going to present an exigency that's going to warrant, but it's not always the case.
But isn't it here also, it was in Sakia, also a presumption that could be rebutted under certain circumstances, perhaps not present here?
It says it's rebuttable, but I think in practice, it's effectively an irrebuttable presumption, especially in the marijuana context. Because in the marijuana context, the whole point is the presence of marijuana doesn't give any indication of danger. So I don't know how a defendant is supposed to disprove a danger he rejects exists in the first place.
Well, hypothetically, you could have a situation where an individual was leaving a medical dispensary, had marijuana, had a prescription. There could be facts, not present here, that could rebut the presumption that there's a connection between crime and use of marijuana. But in this circumstance, none of those are, I don't think you've pointed to anything that would rebut the presumption here.
There's not that, but then I think it goes back to when it comes to these warrantless intrusions, it's the government's burden to, initially justify that intrusion, not on the defendant. And so in that case, the onus should be on the government to show not that any safety concerns were allayed, but that they were present in the first place. And I see my time has expired, so if there are no further questions, I
Thank you,
reserve
Counsel.
some.
You have some time left on rebuttal.
Thank you.
Counsel?
May it please the court, Amy Ray for the United States. Your Honors, under Rodriguez, it's a three-part inquiry. First, did the officers divert from the traffic-based inquiry and the mission? Two, did that deviation prolong the stop? And three, was the detour supported by probable cause? And in Palmer, this court stated, unless Palmer can demonstrate some constitutional violation between the time the stop began and the point the officer smelled marijuana, the evidence cannot be suppressed. I believe that that three-part inquiry and the facts of this case establish that the stop was not prolonged within the 30 seconds between the time that Agent Cortell got into his car and Officer Hayes smelled the marijuana. I would remind the court that this is an objective inquiry. Whatever Hayes was thinking in his head about what he was planned to do with that probable cause is really irrelevant. What matters is, did probable cause or reasonable suspicion exist? And if it did exist, then there is no constitutional violation because the officers had reasonable suspicion to search the car to detain Mr. Carson.
So, Counselor, are you saying, is that argument based on the fact that 30 seconds isn't enough to prolong the extension? I'm going to make sure I understand what you're getting at. Is it?
Sure.
Are you talking about because it's only 30 seconds, we don't have an issue?
Well, I think the 30 seconds is relevant to determining whether we have an issue, but the original argument was that the inquiry with Officer DeStefano about the drug dog, do you have anything else? And the 30 seconds is 30 seconds within 2 minutes that Officer Cortell was in the car. So, in other words, the district court...
So I still want to make sure I understand you.
Yeah.
So, when Hayes smells marijuana,
Yep.
Your argument is there's probable cause at that point.
That's right.
Okay, so I think I hear you saying that what's the situation up until that time?
Mm-hmm.
Are you saying that, tell me about the 30 seconds, I want to make sure I understand that.
So the question is, did it prolong the stop?
Right.
And I think I have a couple of different arguments with respect to that 30 seconds. First, under the facts of this case, we can defend the inquiry into the car and into the owner, and I can go into that. So they would have to show that within that 30 seconds, the stop was prolonged. So the first issue is there's no evidence to suggest it was. And the second would be, given all of the things that Agent Cortell testified that he had to do, which included finding the citation book and looking up statutes and, all of that, the district court's determination that the stop was not delayed by that 30 seconds.
So your point is the part of the activities that the officer did that aren't prolonging or even argued to be prolonging.
Right.
There's no showing that they took less than 30 seconds.
Exactly,
Yeah.
or that they could have.
Yeah.
Now, I will defend the officers, Agent Cortell's looking into the, what had happened with the car. He explained in part that because it was an unlicensed, suspended license seizure, that car, something was going to have to be done with the car. And so, and as Your Honor noted, there could be other reasons that that car had been involved in a crime, et cetera. And that's reasonable for safety reasons to look that up. But he also, for traffic-related purposes, what was going to happen with that car. And he did testify, I think it's at page 201 or 204, that, I think it's 204 of the joint appendix, that the passenger matched or closely matched what he saw with respect to the owner. And this court's in Hill 2017 decision recognizes that it's perfectly appropriate for an officer to investigate not only the driver but also the passenger's criminal histories. So I think all of those factors rebut the suggestion that by looking into the owner's criminal history, there was somehow a violation. But I would also, Your Honor.
So just to follow up on the Hill question, the Hill question, the Hill does talk about the other passengers there. You can ask for their license and run a check on that.
Mm-hmm.
But I think the argument would be, you know, if you don't know that the owner is the owner,
Mm-hmm.
you're not doing that. You're running it at the time you're doing it, at least on someone you don't know whether it's in the car or not.
Right. Well, first he ran the registration,
Mm-hmm.
and he says that the image matched or closely matched. I think there's a reasonable inference that at that point he thinks perhaps, and I'm not sure about what my friend talks about in terms of the later video and what it says because I don't recall that. But I also believe that it was perfectly appropriate under this court's precedence for officer safety reasons for him to check on the criminal history of somebody who looks, of the owner, if the owner resembles one of the passengers. And that's what he testified to. So
We don't have any evidence as to how long any of that took.
No, we don't, but we do have evidence as to all of the tasks that Officer Cortell had to accomplish and the particular circumstances of this case, which is that Agent Cortell, was an ALE agent who really was relatively unprepared for the traffic stop, but empowered and authorized to conduct the traffic stop. So what Rodriguez says is that you can't do sort of a reasonable time period test, right? You can't say, well, this officer conducted the stop in 2 minutes. Most officers would take 5. So he's got 3 minutes to go into, investigating some other possible crimes. In this case, the officer was sort of the opposite of that, probably the quintessentially inefficient officer. So considering all of the things that Agent Cortell testified that he still had to do, it's perfectly reasonable for the district court to determine that even if the inquiry into the owner took, 5 seconds, 10 seconds, 15 seconds, 1 minute, that it didn't delay the traffic stop. It didn't prolong, I would say, Mr. Carson's seizure. I would also say that the other facts that are really important here are what Agent Cortell did discover about Mr. Washington. He was what he called Agent Escobedo, Officer Escobedo said that, I'm sorry. But he did learn right away that Mr. Washington, the driver, had violent felonies and was considered a violent offender. So that would have heightened the safety concerns. And so whereas in a normal stop, perhaps checking the owner's history or criminal history might, I don't really think that makes sense, but especially if they resemble one of the passengers. But even if it did, in this case, we do have heightened safety concerns. And he also knew from the briefing he testified that these gentlemen he didn't know at that point that Jermaine Carson was in the car, but he did know that Calvin Washington was suspected of engaging in very recent criminal activity just a quarter mile away at the Aston Park Apartments. So with all of those circumstances, the district court did not err when it determined that the inquiries that the defendant suggests are violated his constitution, that they did not prolong the stop. And as long as it did not prolong the stop, there is no constitutional violation and no basis for suppressing the evidence. Turning to the frisk, Saki's good law. In addition to that, and I will note, not only do we have Rooks, but there's a 2019 McCoy decision. It's unpublished in this circuit, but it did say that even though marijuana, the possession of it is legalized in many states, that does not undermine Saki. And of course, it's not legal in North Carolina for any purpose. The possession is not.
Wasn't it just reclassified last week by the federal government?
Well, yeah, I think that's right, Your Honor. But it is still not legal to possess in North Carolina.
But it does seem that the presumption from decades ago of a nexus between marijuana and criminal activity does seem to be particularly weakened because of the changes in the law, both at the state level and the federal level. And it just strikes me that if the Saki presumption is maintained, then really any marijuana user effectively loses their Fourth Amendment rights when they're using marijuana, whether in a car or on the street. The presumption seems particularly problematic given the changes in the law.
I don't disagree with Your Honor that the law seems to be, evolving when it comes to, or at least the circumstances when it comes to marijuana.
And not only the law, the who's
a danger.
Or
Yeah.
who's a, right. The
Sure.
connection between criminal activity and this particular drug seems to be weakening.
I think that's right. I mean, I also think that, the criminal activity is there in North Carolina. There's no question that it's unlawful. But the dangerousness, I think, is what is fair to say is evolving. Like whether or not we can assume that someone who's violating the law because they are possessing a small user amount of marijuana or whatever, whether or not that suggests that they are automatically dangerous, that might be something that this court at some point will reconsider. I do note, as Your Honor did during my friend's argument, that there is a way, what Saki says is, unless the facts ameliorate the safety concern. And there were no facts that would ameliorate the safety concern in this case. By the time they frisked Mr. Carson, Officer Escobedo knew that he had previously been convicted of armed robbery, kidnapping, assaults, and they had seen the digital scale that had white residue on it that was consistent with fentanyl. So this is not that defendant that we don't have to be concerned about. So I don't think that even if this court were to consider or want to revisit Saki, that this is the case, this is the best vehicle for doing that. And of course, this panel wouldn't be empowered to do that anyway. So there were many facts in addition, even if in this case this court were to say, throw Saki out the window, we still have sufficient reasons to suspect that Carson could be armed and dangerous based on his criminal history and what they had just seen him doing in Aston Park Garden Apartments. So they had seen him in particular with Calvin Washington engaging in what they understood looked like drug trafficking and among a group of people who were carrying firearms. They never saw him specifically carrying a firearm. But as Officer Escobedo is the person who said this was a person we knew, and a person we knew presented a danger to us, potentially, and of course the Supreme Court has recognized many times how dangerous traffic stops are for police officers. In this case, it was reasonable for them to determine that he could pat him down. If Your Honors don't have any further questions, the United States respectfully requests that this court affirm the judgment of the district court.
Do you have anything else? Thank you.
Thank you.
Thank you, Counsel. Ms. Baldwin.
Thank Thank you, Your Honors. So the government laid out the three prongs here that they have to meet. This was a warrantless seizure. It's the government's burden to prove that it was reasonable, and its failure to prove that Courthouse stayed on mission up until Hayes developed probable cause is fatal to that claim. As the government has just now admitted, whether it was 5, 10, 15, a minute in, they acknowledge they do not know what Courtell was doing in the car, but we do know that he admitted to going off task by looking at the vehicle's criminal history and its registered owner's criminal history. And I just want to correct two things. The government said that he was also looking up the statutory subsection. JA 249, Courtell acknowledged he didn't recall if he did that before talking about the drug dog or after. And then JA 219 to 220, he acknowledged that he was not looking, that he only looked for his citation book after the drug dog discussion. So those events were not occurring during the 2-minute frame that Courtell was in his car where he went off mission.
So, counsel, let me make sure I understand one thing about the 2 minutes and the 30-second issue. So putting aside burden of proof right now, isn't it correct that if that what would have to have happened is that the detouring activity, or that the officer was not doing legitimate work relating to the traffic stop for more than 30 seconds?
So not necessarily, because if Courtell had checked Washington's license in the first 5 seconds, then checked the registered owner's criminal history at 6 seconds, then went back to looking at proof of insurance. So it could have flip-flopped back in between the two. The problem here is we know Courtell went off mission, and contrary to Rodriguez, the government failed to show that he diligently pursued the suspended license investigation without going on a fishing expedition.
But do we, recognizing that the government has the burden at the motion to suppress hearing, don't we construe the facts in the light most favorable to the government when a denial is appealed?
Yes, that is true, but viewing the evidence in the light most favorable can't cure evidentiary deficiency or gaps in and of themselves. If I have the burden to prove a notice of appeal was filed on January 1st, and I submit an affidavit saying I filed it sometime between December 31st and January 2nd, I don't think anyone would say I've proved more likely than not I met my burden. And that is what essentially the government did here. Like, he did something in the car, we don't know when, but like maybe it didn't. And so we'd say the evidence in the light most favorable does not help the government because they simply failed to show Courtell's actions in the car, notwithstanding his admission to doing tasks that were off mission. And then going on to just the second point, which is the prolongation, how long does not matter. The fact that the traffic stop should have taken 10, 15, the fact that Courtell was engaged in tasks of whatever length necessarily added time to the stop, because rather than looking for his citation book to complete the stop, he would instead spent that time going off mission by looking at the criminal history of the registered.
So you think him, because he also testifies, and I brought this up earlier about having to do this the two-step authentication, is that off mission also? I mean, during that 30 seconds?
So I think he did have to, I think booting up the computer, I would say, is required. So I think he couldn't identify when exactly he did that. So he thought maybe he did. So, but nonetheless, yes, that was part of what.
We know he had to do it in order
yes.
to do the additional, and he couldn't look up, I would assume he couldn't look up the registration or any of that stuff without booting up the computer, right?
Right.
Okay.
And just real briefly on the going back and forth, I'm trying to see if that would matter. Let's say he did some stuff that you say was permissible in response to the traffic violation, and then kind of did some stuff that you think was a detour. I mean, isn't still our question whether the evidence in the light most favorable to the government would be that the undeniably proper things take more than 30 seconds? Because even if he flip-flopped, the issue is whether it's prolonged. And if it seems to me, I'm not understanding how the possibility that they did some things that you say were okay and some things that you say were not, maybe not consecutively, makes any difference.
So my time's up.
Yeah,
right?
sure.
So it does matter in the sense, you know, the Third Circuit in the Hur case said, the problem is any break in the mission taints the stop because it's the result of unreasonable delay. So whenever it happens, regardless of whether or not other things remain to be done, doesn't matter. And so, I'm sorry, I feel like you have made a couple of points in the question and I only recalled
No, I
some
think
of
you
them.
answered.
So-
No, I think you responded.
I'm sorry, and then the other thing I wanted to say is, I don't think we can assume how long the appropriate inquiries had. There was simply no testimony on that, one way or the other. I have no idea how long any of that takes, and I've looked at a number of these suppression motions. It often doesn't matter. The problem is it mattered in this case, and the government didn't show it. So if there are no further questions, I appreciate your time. Thank you, Your Honors.
You have any questions?
No.
Okay. Thank you, counsel, and I note that you're court-appointed, is that right? And we appreciate your work in this matter. That makes us able to do the work we do, and thank you very much for doing that. And Ms. Ray, thank you for your service to the government.
Thank you.
All right, we'll come down and greet counsel and adjourn court till tomorrow morning.